All right, I want to welcome everyone to today's webinar. We'll go ahead and get started. Feel free to join in progress. This recording, we are recording the event, and we'll be happy to send that out afterward. Good day, everyone. My name is Julie Parks. I am the Chair Emeritus of the American Association of Exporters and Importers. AAEI is very pleased to welcome you members to this free webinar. We want to help our members continue to realize the value of this amazing association. So thank you all for being here. Today's webinar will explore how emerging technology should be adapted to support and not hinder your compliance program. We want to give a shout out to our Apex sponsors for their support and help in making this webinar possible: Sandler, Travis, and Rosenberg, and Sayari. Before we start, allow me to brief you just a little bit on the AAEI history on this topic. So in June of 2023, at the AAEI conference, I had the opportunity to host a panel discussion on technology's impact on reasonable care. This session provided some foundational information on the solutions out there, how we adapt our compliance program. We had an incredible dialogue about how we should think about responding to customs inquiries and reasonable care. Well, in that dialogue, we were kind of missing the voice of the law, right? So since that time, another piece of information happened that Customs and Border Protection they're actually adopting some use of these technologies. And then we also had some really interesting uses of some of these capabilities in the forced labor space. So today, we're so pleased to continue this dialogue, dig a little bit deeper to understand some input from a very knowledgeable and trusted expert. You guys probably know her very well too. In the background, I'm very excited to introduce our speaker today, Sandra Lee Bell. She is a partner at Ramon. She represents clients on regulatory procedures relating to customs, tariff, and import issues. She includes securing and responding to decisions on prospective and current import transactions. She is involved in international trade policy and regulatory programs and border security. And of course, Ms. Bell brings with her 3 decades of customs experience at U.S. Customs and Border Protection, where she held several positions, the most recently as the Deputy Assistant Commissioner, the Office of International Trade, and as the Executive Director of Regulations and Rulings, OT. Just a bit on Sandra's background too, because I always love to brief a little bit about the history. Her education, she attended the John F. Kennedy School of Government at Harvard. She received her JD from George Washington National Law Center and her BA in summa cum laude at Howard University. So good afternoon, Sandra, and thank you very much for joining us today. I know we've prepped you with some historic AAEI information, so why don't you go ahead and take the stage first and share with us some of your insights on the topic.
Well, thank you. Thank you, Julie, for having me. Thank you, AEI, for having me. And thank you, members of the association, for taking the time to listen to what I may have to say about AI and reasonable care. I appreciate the background information when I was invited to speak to you in this webinar from AEI, because the background information included a letter that the association sent to Customs and Border Protection EAC Highsmith about using AI for purposes of determining reasonable care in connection with a lot of matters, but primarily focusing on tariff classification. And that letter was sent back in 22, before I think you guys had a meeting or discussing it last year. But I thought, before getting into some of the issues that you raised, pretty much I say raising it formally when you sent the letter to the EAC about using AI and acceptability for purposes of reasonable care, I think we should take a step back and, how do we get to reasonable care? What's the background? And so let's just take a look at some of the points that I put in the first slide for our discussion today. So many of you know, this is the next slide, sorry, Chris. Many of you know reasonable care was something that it's stated in the law. 19 U.S.C. 1484 is the standard by which importers are supposed to file the entry declarations when they got the affirmative obligation under the Customs Modernization Act of 1993 to correctly classify the merchandise and to correctly appraise the merchandise, correctly declare country of origin and everything associated with the merchandise. And so, you know, it's in that backdrop that the reasonable care obligation started. It's in the law. In return, CBP, the agency, was supposed to be making all the importers' obligations under the law and regulations as clear as possible for a layperson. And that got the nomenclature informed compliance, which took many forms, but the most popular form was the informed compliance publication. You know, they start out with everything you want to know about such and such, you know, but might have been afraid to ask. And that's the trademark, you know, no, that's a trademark phrase before a reasonable care informed compliance publication. The reasonable care publication coming out in 1998 was among the first of the general ICP, informed compliance publications. You know, just providing pretty much that the examples of things that you should be doing to demonstrate the exercise of reasonable care. And then shortly thereafter, you have the reasonable care, the ICP on tariff classification, just the general rules and principles of the harmonized system, the explanatory notes, and the principles for determining tariff classification on specific goods. All of these ICPs that came out, and of course, after that, you had a series of ICPs covering specific types of good. But then you also had numerous ICPs on general issues, even including penalties. And they're all available. You know, Customs has always been a very transparent agency online under the trade page for the website. So, and feel free to interrupt me anytime. I know this is a lot of stuff is what you know, but to the extent that you have a question about something you have been thinking about for a while, even though it's based on stock information that you've had and been using for the years, just feel free to interrupt me. I have no problem with that whatsoever. So in looking at the letter, let's go to the next slide, that the AAEI sent to CBP, they were pretty much asking for CBP to pretty much look at the artificial intelligence technology as has been developed over the years. And as a matter of fact, you know, we all use artificial intelligence technology. You get an email, it's already got the answer to the email before you even read the email, because it's read the email for you and it's thinking of logical responses. And, you know, sometimes you appreciate that, sometimes you don't. And sometimes you appreciate the autocorrect of words, and sometimes, or the finishing of a sentence, sometimes you don't. But in connection with the existing reasonable care ICP that CBP has, as you are aware, it's a series of questions, you know, basically asking what you did. It's looking at certain activities that the importer should have taken and asking the question, have you taken these steps for purpose of supporting your exercise reasonable care? You know, it's basically stating you're not going to develop a list, and neither is CBP going to develop a list that's going to be considered to be foolproof, that you will answer or have asked all the possible questions. So, you know, what the AEI proposed to CBP, and to my knowledge, it hasn't been implemented. Of course, I'm not even sure how much is being seriously considered at this point, but they wanted to add to the question in the ICP relating to whether or not they've consulted a customs expert, the phrase and or, you know, whether or not we've leveraged the HS derivation technologies to prompt quote unquote expert review when appropriate HCS, as to when an appropriate HCS assignment cannot be determined. And
Sandra, we're having just a little bit of technical difficulty hearing you. Folks, if you can just hold on for one moment as we, Sandra, are you good?
Yeah, no, it dropped off for a minute. So
perfect. We are back.
We're back. I'm sorry. Okay. Actually, that was a good spot when it dropped off because I was actually mixing up the ICP on tariff classification versus reasonable care. So the reasonable care ICP, the latest one, I've always thought very interesting. You know, this came out after my leaving the government, where you have a series of general questions, but then you have specific questions related to specific areas. And of course, as indicated by the specific questions in specific areas, tariff classification and description is one of the first areas identified where they have a series of questions relating to it. And that's to indicate that that CBP has always recognized that that's an important and a serious burden that shifted from the government to the importer back in 1993 and 94 when it became effective under the MOD Act. So the AEI is suggesting that in the list of questions under the ICP relating to merchandise description and tariff classification, that you add the question, does your HS program leverage HS derivation technologies, to understand the merchandise as it relates to the HCS, to include the something that would prompt the use of an expert, and whether or not it's being used to serve as a resource for responding to CBP inquiries. So that's adding another question to the series of questions that the importer is already obligated to, not obligated, but encouraged, because that obligation to consider with respect to supporting their obligations of reasonable care. And then let's go to the next slide. Now, getting back to the tariff classification and foreign compliance publication, as I mentioned, one of the earlier ones, telling you about the principles of determining tariff classification, the rules, GRI rules, for determining classification, the EN explanatory notes, and how you would apply those to the particular merchandise that you're looking at for purposes of reaching a tariff classification. In connection with that, the AEI is recommending that the AI be used to enhance the support for determining tariff classification per se. Now, one of the things that is of note, even in the recommendation, and that's one of the things that you have to sort of consider, well, how far are we going with this? It's describing, how AI works. It's basically saying it's learning from pretty much data that's input to the system, the historical product classification, and it's building the algorithms to generate a list of quote unquote plausible classification suggestions. And, when there's a high confidence at being achieved, and it would enable future tariff classification based on that algorithm and that result from using AI in that sense. It says AI, now this is the part that's, I guess what we looking at. It says AI classifies the product, take into account the intended levels of confidences and accuracies. And the algorithm developed by AI will consistently apply the same logic and decision-making mechanism to new products, meaning that consistency in classification will substantially increase when compared to manual decision-making in determining classification. So let's go to the next slide. So this is where I think we do sort of have to look at this in context. What's the elephant in the room? You're proposing the use of AI, and you're proposing it to be something in addition to consider for purposes of determining whether or not the importer, and this is usually the importer or the importer's agent, is exercising reasonable care. Are we trying to seek the AI-derived determinations to be used for definitive determinations for the product being imported? One of the questions we're asking is well, who is providing the AI-derived classification determination, either directly or indirectly to CBP? Is it the importer? Is it a licensed customs broker or the importer of the importer? Or it's a third party? And if it's a third party, will the AI derived tariff classification be provided to CBP for a customs entry declaration for the imported goods? We have a customs business question. We have some rulings to consider. One that came out in 2017, H272798, and one that came out in 2022, H290535. So what I'm looking at is, if it's the importer, no problem. Other than when the importer, it just deals with the question of whether or not the importer is exercising reasonable care. AI is just, they are distinctly related to reasonable care. If it's being used by the broker itself and not another entity to reach the classification determinations to the broker's clients, importers, entry filing, also, I'd say no problem, other than whether the broker is exercising reasonable supervision and control over the operations and processes for presenting entry information on behalf of its client. But if it's being used by a third party to provide determinations reached on entries, specific entries filed with CBP, I think this can open up a whole new can of worms. And it's sort of illustrated in the two rulings I cited. In the 272798, this is the one that came out in 2017, CBP ruled that a tariff classification database that is used as a quote unquote resource coupled with a disclaimer that is meaningfully executed. The disclaimer in this case included a statement that the specific tariff classification to be applied to specific entry is to be determined by a licensed customs broker. And if it's implemented exactly the way it's written, the preparation of that tariff classification database would not be considered as customs business. But then in 2022, with the same, I would say not the same issue, but a different situation, where you had, this is the ruling that came out under 290535, you had a situation where a company, and more like the seller, there's no indication it was a foreign company, it was a seller maybe using foreign resource for that, was providing the HTS classification at the 8 to 10 digit level for specific merchandise purchased by its customers for importation. And CB ruled there that went beyond having a tariff classification database for general reference purposes, because the step of providing specific subheadings for specific goods that will be subject to entry required a customs broker license. So the elephant in the room here. Let's get to the last slide. That's not the last slide, Chris.
Sorry, did I miss that one? I apologize, guys. Let me go to that.
I'm sorry, is that the last slide?
Not necessarily. This is
okay,
more. This is continued. I apologize. I should move to this one.
No problem. Let's go to the very last one. Well, no, actually, no, stay back to that one. I'm sorry. Let's stay back. Let's go back to that one.
There we go.
Because I wanted to talk about that too.
Here we are.
Okay, just give me a second. Get my stuff a little bit where I can see it better. Because this is the one where I thought, the ruling in 290, the 2022 ruling, this is where I thought, CBP acknowledged, that, many of the checklist questions in the reasonable care ICP contemplated the use of an expert or a consultant, and still highlighting the need to do more for reasonable care. It basically finding that company, in addition to, which is also, I thought, creating a lot more gray areas there, in addition to needing to have a customs broker's license provide that specific level of details for its own customers, imported the product would not qualify as an expert for its customers for purposes of the exercising reasonable care by consulting a customs expert. And so I thought that was very interesting because it would be, I would assume it's possible that that company was using AI technology for purposes of assisting it in coming up with a tariff classification, or maybe they were doing it manually. But in either case, CBP was not recognizing that it was allowed to do that without a customs broker's license, and not giving them credit for being a customs expert for purposes of the importer, considering what was provided to them as having consulted a customs expert. And there was also a court decision, that's the one I cited there, where, here again, we have the court finding the opposite of reasonable care means you didn't exercise reasonable care, so you were found to be negligent. And so you have a scenario where they're still going back to those checklist type questions, as well as just finding that, if you haven't done enough in terms of responding to the checklist type questions, since it's an automatic burden shift to the importer, once CBP establishes a material falsity, and having the incorrect tariff classification has been held multiple times to be a false statement, then the burden automatically shifts to the importer to show that it has not, it was not negligent. It doesn't say that it's just that you show that you exercise reasonable care per se, but the allegation is that you were negligent. So it's almost the opposite, a negative burden of proof that you have. So, the checklist that you would keep going back to, a checklist would be things that you could possibly do, but then you have CBP saying up front, that it's not exhaustive. And the import itself really cannot come up with an exhaustive list. So let's get to the last slide, because this is where I'd like to get some input from you. This is where we're going. Will the general availability of AI for having it generally available for using HCS classification determinations reduce or add to the importer's reasonable care burden of proof? I mean, even in the proposal submitted by your organization, you point out its limitations in the letter, and basically saying it's not meant to replace the need for human classifiers, but instead meant to shift a day in the life of these classifiers, allowing them to focus on the more strategic activities, such as classifying lower confidence complex new products, conducting audits on high confidence classifications, and AI maintenance activities, such as updating the tariff with new ruling publications. So, what do you think? Is this something that you want to advocate to be a formal process for a checklisting of reasonable care, or is it something you just like to be able to do? And I'm only referring to the reasonable care context of tariff classification. But as Julie mentioned earlier, there are many other activities for which AI can be used in the customs importing process. But we're talking about the tariff classification determination and trying to tee it up for more recognition. CBP has never answered the question, defined reasonable care. The court has not answered the question as to what's reasonable care, defining it. As a matter of fact, in the last ruling that I mentioned, CBP said it cannot issue a ruling. The importer asked, whether these activities are reasonable care, and it said we cannot rule whether or not there's reasonable care. So I look at reasonable care as being one of those things. I know it when I don't see it. But I know when I don't see it. I don't know when I see it, for purposes of having a clear definition. And so it is in that context that you are looking at trying to get more formal recognition of reasonable care support from AI. And that's, that's a scenario and that's a setting you're in. I mean, and I think, Julie mentioned the fact that CBP uses it all the time, but they are not using it to make definitive determinations relating to the core things such as classification and value and country of origin. If they are, they're not noting that publicly. And then we see that Congress has been very critical in some cases of how they're using it for enforcement purposes. Mm-hmm. But I'll stop there for questions.
Sandra, thanks for your insights. I think you've guided this discussion through a really interesting path. And I think I'll share to the team. So from an RTX perspective, we are publishing guidance for our company when it comes to their use of AI and how we should be thinking about it. But what is very interesting about this discussion, and we might be thinking about it from export controls perspective and HS, right? And when you think about FDA numbering, right, you think about ATF numbering, right? They all have different trade numbers. We can use some of these common capabilities to kind of derive. The part that's really interesting in your discussion, and thanks Mark Herzl for your comment because you picked it up, was it seems that the reasonable care standard may apply to the expert that set up the database to begin with, right? So kind of like, did we have expert review on that test input of data? And then when we get other parts replicating and moving through, you can kind of say from a reasonable perspective that, look, I had an expert classifier reviewing these things, but I want to stop and kind of get your thoughts on, so like, is the workaround that I'm putting the rigor on the setup of the AI and thinking about who is involved in that? Is that kind of what you're saying?
I think so. I mean, if that question is to me, I think the reasonable, and that standard is going to the importer, so it's not going to apply to the entity involved in setting it up. And so whoever's supervising that for purposes of using that information for importing goods based on the determinations made, that's where the reasonable care standard would apply in that light, just for that action. Mm-hmm. But I'm just getting back to the part when you're talking about tariff questions. I saw a question that popped up. Yeah, I think importers are free, and I think they probably should use it for expediency for purposes of making sure they can get the easy things done. It's just that the expectation that you would be getting credit for that from CBP is probably a little too exaggerated, because there are just too many caveats that they will put around that.
Excellent. So then let's continue. So setting up the database, very much taking into consideration reasonable care in that case. And then I think the transfer of that database and kind of worrying about the customs business thread, making sure that that's in order is kind of like that second piece. But the third piece we got a question in on is kind of that aspect of, okay, so now you've got the machine running and you have a recommended classification from this AI tool, and usually it spits out a confidence level. I'm 100% confident. I'm 40% confident, right? Are we talking about, like, let's talk about the aspect of, does that human need to be necessarily in the loop to say, I accept that classification and I've assigned it? Or can the system actually move forward and assign the classification because you're going to lean on the fact as an importer exporter that you've set up your database, like the AI tool itself, using reasonable care? So therefore that is considered my expert now, right? So maybe do I have to, or don't I have to put an expert on each part saying, yes, I accept the tariff, or no, I reject the tariff, especially when the confidence rating is high. And that's the stuff that we've been struggling with, Sandra. Like, maybe thoughts in that space on the actual assignment. Do we have to have a human in the loop?
Well, I mean, I don't see how you're going to not be able to argue that you've exercised reasonable care without a human in the loop. And we have a scenario where CBP is not going to accept the database result as being the expert, and you're relying upon the expert and just accepting what came out of that. And we saw that because in a scenario where CBP allowed the database to be used, it said that the disclaimer scenario required that a licensed customs broker accept that for filing the entry. And so the licensed customs broker is a recognized expert in tariff classification. But you saw a situation where a company, and it wasn't even described how they were coming up with the determinations of tariff, it was coming up with a specific tariff classification for the specific product they're selling for import in the US. And in that case, CBP was saying, first of all, they needed a license to be a broker, and it was not accepting their determination as having come from an expert. Mm-hmm. So I think it's the scenarios that would allow the data, the determination from a database alone to be accepted for reasonable care purposes would be very, minor, very, very little. I can't imagine any, but I think you could still do it. That's just your way of doing business, because there's no way that, all of your classification determinations will be examined on the basis of reasonable care. So that gets back to the businesses, I guess, staging, triaging in a sense, which classifications they would like to be able to just have done by the AI, very, very relatively easy, simple, and which ones are complicated. New products, I don't think you want to give to an AI system.
And it really is interesting, Sandra, because I think that's where we're looking at that probability piece as being really important in the dialogue, because when the AI tool says, I'm 90% confident, I'm 100, and then we go, we've set up our compliance program, we have got the expert in that training data, so that maybe when it hits that higher mark, the probability, because maybe the aspect is the probability of getting it wrong is so low that even if customs comes and asks a question, the number will be correct, and therefore we will never go down the path of did the assignor, work through the reasonable care standard, because the number will be right. So just
yeah, I think in that scenario that's right. I agree with that. But just keep in mind, we're still dealing with, if you're doing it for your own company and it's you bought a software that's doing this for you, that's not an issue. But if you're using another company that's providing you the software and providing the conclusions out of the software that they're employing, and that company is not a broker, then you get into the whole issue of how definitive is that classification how definitive is the classification that you're receiving that will be transcribed onto the document you're filing for specific goods. And then you get into the customs business piece. So it's a very delicate area. But I think there's room for using it a lot in tariff classifications, but not in the regular entry spot for reasonable care. You can use it, but I'm saying don't think that's going to get you the reasonable care checklist.
Right. Now the other interesting point. So we got some thoughts from Joseph in our chat. So Joseph is sharing, look, maybe some of this also comes down to like you are experiencing in your compliance program an excellent setup process. Like, so your training data is amazing and you're right. And then the next piece is when the assignment comes, kind of using that piece of what's the probability of goodness that's in the number that's recommended, right? And then kind of the third step, we talk about using experts to actually accept the classification in those, kind of, less desirable numbers kind of status. But then the other part is when you move through the system, the why is this number correct? And kind of documenting in the system, I believe this number to be correct because I'm documenting evidence that kind of shows my audit trail. So what's GRI did you kind of reference? Any thoughts on kind of the hallmarks of what that goodness might look like? What is the evidence that might be required? Because I know everybody's kind of, we're revisiting this, and we had things in a human world that were very, rigorous and steady, but just curious your thoughts on how we should be supporting our classifications and maybe getting these AI tools to think about it the same way.
No, I think what you just described would be the way to go with that. I mean, I don't see anything to detract or even add to what you just said. And I think that, I just know companies do it. They use the database, they're putting information in regarding their product description, and they're coming out with tariff classification, and then they're auditing themselves based on that database determinations to see whether or not It's close to what's, they would have come out manually, it's sampling the determinations per product to see how well the AI is working. And so I guess my suggestion is that, well, I would never want to, from my perspective, advocate formalizing as something that you should be doing if you can do it, because then your organization is huge. You may have entities that are not able to even incorporate this database process. You have just enough people, to manually classify it. And now all of a sudden now you have someone coming through doing the customs audit. And when the question is, what are you using a database? Because it'll probably end up getting cheaper. So it would be something that everybody's considered to be able to afford, like you can afford a customs broker. So it is one of those things, since they're not going to accept it definitively for purposes of determination because they got too many caveats, even when you are using a customs expert, and they're basically not accepting it to be definitive as proposed, because nobody's going to ever propose it to be definitive.
Right.
I think you should use it though to the maximum extent possible, to provide more efficiencies in your work processes relating to fulfilling your overall obligations for reasonable care. How you can, like I say, you're triaging the more difficult, the newer products that are coming online in your given organization. But in terms of trying to be encouraged that determination coming out of that AI database or process is going to be accepted by CBP, that's a long shot. They're not. I mean, they don't accept the ones that you do manually automatically. But if you show your process for getting it is being what they've considered using reasonable care, they could disagree with you, but then they can't penalize you. But we know basically what we know is what we've seen, through more than anecdotal evidence, but you guys' real experience. The only time you get totally out of being penalized with a negligence penalty, is if you got advice from a customs attorney or a broker specifically addressed on that product and said it's classified under X. We advise you to do that, and that's based on getting all the facts. And I think they'll look at that if you can show that's what this person, the attorney said, this is my opinion, the broker says my opinion, it's somebody who's recognized as a customs consultant, because they consider that they pretty much didn't recognize that company. It's hard to see where that is these days, but just assuming it is, then you got it in writing, that's your check mark for having exercise reasonable care, and you will not be penalized. But as we all know, even when that's the case, because sometimes you're going to get an opinion, you're going to get advice from a broker relating to a specific product, and the importers, on their own will say, hey, this is just like this, let's use it. And, who's argued that that's not reasonable care? You're allowed to exercise common sense. But we all know when you discover that problem on your own, what are you going to do? You're going to make a prior disclosure, because CP is not going to, your determination is not going to be accepted as being the determination, right? That they disagree with that. So what do you want to do is get credit or just pay the duties. But theoretically, you're not even supposed to have to pay the duties if you were negligent. But nobody wants to really go that far and say, well, I'll make that argument, because that burden is too heavy. I mean, we've numerous court decisions on that, and proving that you've done all those things on the checklist, which is not exhaustive to your reasonable care.
So it is interesting that perhaps we need to kind of, from an AAEI perspective, think about what a reasonable care kind of a checklist might look like, but perhaps not, we don't need to share it with the regular, but maybe that's something. So Karen Lobdell kind of shared in the chat, should one of those questions that we're kind of asking in that room, in that are we exercising reasonable care, is how are your algorithms designed? Do you have licensed customs brokers on staff that are designing those algorithms? Is kind of getting down to kind of that questionnaire to say, I think I'm doing this the right way and I'm meeting customs excellence standards. What are your thoughts on that, or any additional questions that we might need to think about on our checklist?
Yeah, no, I really think that that's something that is good for if you want to try to argue that using the database in and of itself is exercise reasonable care. And that only goes to that. I just really don't feel encouraged that that's going to be ever a determination. I mean, but it's fact specific, case by case specific. So a particular scenario may have CBP making that determination. I mean, I just don't see that. But I see your AI use for tariff classification coming into play, which I just mentioned. If you're making a prior disclosure,
Yeah.
you're going back.
Well, it's
5 years.
interesting, Sandra, do we need to say, how much do we need to say if we're moving into a prior disclosure or if we're responding to a CF-28? How much, how much detail do we need to get into other than we got it wrong and we'll do it right? I feel like we have to kind of explode the sad path of we got it wrong, right? In this case, thinking about the scenario.
You got it wrong, and so you're dealing with the prior disclosure or even in an audit, and CBP is basically saying, "Hey, make the correction."
Right.
And you're talking about 5 years worth of entries, thousands of entries. You're going to probably argue for statistical sampling, if it's too voluminous. And there's got to be a process for classifying the products. If you could do the AI database and get them all classified properly versus using a statistical sample, you may come up with a better result. Or you could do manually and do a stat sampling, but you've done manually, extrapolate it out, and that's another result. But once if the burden is on you to make the tariff classification, to provide the correct information, and then if CBP questions it, then it's tested, of course, on a manual basis. But I see that tool will be useful under those circumstances because you're dealing with high volume of entries, and you're dealing with a scenario where it's the evaluation is not going to be entry by entry by the government. So it's a question of what's going to be the most logical. And I think that's where the question comes into what's the process, or what process that you use to develop the AI that's being used for that purpose. What information got into it? What is the algorithm based on?
So let's, Carolyn has an interesting question. So, hey, isn't the legal concept of reasonable care referring to a human? Right? Could it ever refer to a machine? And to the state AI as satisfying reasonable care might remove the human if we're not keeping the human in the loop, right? And I guess, more along those lines, has AI reached the level of sophistication or confidence that kind of does get to that human element or that human replacement piece? Any
Yeah, it does to a certain degree. To a certain degree, but you're not going to get it being by itself because it's not going to be any more than the database that CB's already looked at and said it has to be validated by a human, the licensed justice broker, being in the room or at least looking at it. So it's not going to ever take the place of a human. You're going to have some adjunct human involved, but I think it could take the place of many involved,
So let me pause. I know I made it through all but one of the questions that are in the chat. I do want to make this not a Julie and Sandra discussion. Is there anybody that wants to come off of mute and ask a question? That's also allowed too.
Yeah, welcome it, because I don't have all the ideas. You're the business people.
Any thoughts or inputs from anyone else, even if you've already had a question or a follow-up? Okay, let me move into just another kind of an interesting area. So Richard was asking, what else are importers using? So moving beyond the classification discussion, and what else are folks using? So just to share, we've seen AI used in reading commercial invoices, for example, to kind of replicate, oh my gosh, the license field is always over here, and can we get the data right? So translating the paper into data, and again, there's machine learning that might be involved in that, and other capabilities beyond AI, but we've seen that. But the other part that I really wanted to highlight here and focus on is the aspect of forced labor. So on the forced labor thread, there are AI models that essentially discuss the probability of your product where you're importing it from, who you're buying it from, and what's the probability that you might need to do additional due diligence on that piece. Now, Sandra, as you know, as you're following the discussion, the level of evidence that's required from an importer to submit is kind of a high degree, and it goes back to the paper era of the paper trail of show me your supply chain. And I think the kind of dialogue that we're getting into as the trade is, well, customs, you started it by telling us that this was a really good way to kind of perform our due diligence, but will you accept it as, I know that this has a low probability of forced labor, as opposed to mapping out the entire supply chain? So share with us maybe your thoughts on how AI assists and where it might stop in an importer's compliance program kind of supporting forced labor.
Yeah, so from my understanding, just from getting the information from clients and from CBP, they will accept that first report, that identifies by names of the parties involved, going back to tier 3, from the beginning, if you have the names, to the extent that AI can do that. But then if they want to, if they will accept that for purposes of, okay, now we need to verify it. So they'll do spot checks. So the question is, whatever you get from the AI in that process, do we have a document that can support it? And so that's how you do. I think you would have to build something into the algorithm or whatever process will be related to it to I guess, demand, or at least leave open whether or not it exists, so you'll know which document you have and you don't, and you do have, for purposes of verification. Because that's how I've seen it, where, okay, the AI pretty much identified this is going back to X, but so the people who are looking at it before submitting that result to CBP will say, but we couldn't find the invoice for such. We know that this was done, we have no evidence to report. I mean, sometimes that could be accepted, but at least you would have to be prepared to be asked for it. Or decide you'll wait until you're asked for it, as opposed to acknowledging that up front.
Any
The only
thoughts from the
problem is
group?
if you don't acknowledge it up front, and then when they start asking, and it looks like you have hardly anything that's supporting it, then your whole credibility based on this AI has gone out the window.
Right. Any thoughts from the group on the forced labor adaptation of artificial intelligence? Okay, so I also think what's interesting about the artificial intelligence piece is to flip the story, right? So the government is actually using these kinds of capabilities to kind of understand. Now, seems kind of weird that we're kind of held to this standard of reasonable care when we're kind of deploying these pieces. How should the government be thinking about deploying these tools? And I will share too, like we're seeing many different countries. I think India has seemed to embrace this more recently. They were using it for VAT capabilities and whatnot, but more specifically, they were using it to kind of compare where values were differing from an importer's perspective. How should we think about even what the government standard should be? Should we think about as AAEI trying to impose some type of a standard on the government where they're kind of deploying these kind of capabilities? Or is it really just a due diligence piece and you still need to do the work?
You're referring to the government not using it basically? Okay, yeah, I guess they can only go but so far, even on the government side. You're talking about something to lead to enforcement action, such as a penalty.
Okay.
So they're going to still have to have proof on the government side. I think my understanding is the way they use it in governments to decide, as like we just talked about in terms of tariff classification, triaging on the government side, determining what needs to be more focused on with respect to particular importers, using AI as part of their risk assessments and review of import transactions. But if they single out something for action, then you still have to deal with the actual proof of what happened, and the AI process would not get you that. I mean, I thought I read that Congress was criticizing CBP for actually even using AI for that purpose, for screening out, because they thought it was resulting in too liberal of determinations and screening out more than that should be screened out for enforcement purposes.
Correct. And we very much agree with that. Any thoughts on the government side from the group? Okay. And maybe to kind of, before I throw it out to the group for any other questions that they might have, I did leverage ChatGPT to ask what questions I should ask Sandra Bell. And it was actually pretty cool. I mean, other than asking about kind of border enforcement and things like that, which I won't bore you with. I think the other part was that ChatGPT picked up on your rich, like, career path and ask that you share with us about your experience, insights, or advice that you have to trade professionals aspiring to kind of similar roles. So any thoughts there?
Well, everybody knows my trajectory starting out in government and growing up in government. I didn't start from the middle or top. I started from the very beginning, fresh out of law school. So I spent my whole career there. I wasn't planning on doing that. It just evolved over years. But, it ended up being an experience where, you heard the old adage about short-term memory being the first to go, but the long-term memory stays forever. So all that stuff I learned as a young attorney in customs, I still know because that's the long-term in memory, and it's hard to get around that experience. But customs actually, and I'm not trying to put a plug in for customs, but I really don't know any other way to say it other than the fact that there is no other boots on the ground type agency where people can actually learn so much from being on the inside. And that's just, my experience. So if you have time, you have the financial resource, do it. I recommend starting in government in terms of in the area of customs. Short of that, then you want to actually deal with working in an area which specializes in customs. I mean, of course, we have brokers and we have some boutique law firms that do that. But then once you get that expertise, I think you find a way to continue that growth independently without having to be in that environment. So that's pretty much the way it happened for me. I wasn't even thinking. I spent my whole career in customs, joining not thinking I'd be there more than 3 years. And of course, using my resume, I was over there 30 years. And then, wasn't looking to go into private practice. And then I was recruited and by someone who knew me from customs, from my days in customs and working on issues relating to, granular issues as well as in the management areas. So that's how I ended up in the private sector. But I really enjoyed being in the private sector in an international focused private sector, which I like because I get exposed to all kinds of matters and issues, all kinds of companies. That's why, I have such a high respect for our American companies being such a wide variety, because there's so many different types of businesses in there. And that's one of the reasons why I was a little bit, concerned, because how organizations are. Every organization gets, you're thinking about the big picture, but you always have members who are not there at that high level. So to the extent CBP would not have a problem adding anything to the checklist, because that's all it's going to ever be, a checklist. And so you end up being in a situation where and I'm surprised they didn't already do it, probably because they're behind in updating the raise care checklist and all the other checklists. But you end up being in a situation, okay, well, be careful what you ask for, you got it. And now we're going to hold you to it. But they've been being the government. I was there and I use it both inside and outside. AI for ages. I mean, right on it. What do you think Easy Quant is? That's an artificial intelligence that they use for sampling goods, for determining, whether you're high risk or not for purposes of your audit. They use it. They'll allow you to use it if you are trying to make a prior disclosure for multiple entries going over a period of 5 years. If they approve that sampling methodology, that's in a sense, it's economics, it's math. but it's also in a sense using something akin, if not identical. So I don't want to get into the technology, phrases to artificial intelligence. But see, I look at artificial intelligence, something that's got a name recently, but it's been around for a long time. And, but used in various ways that we just sort of take for granted.
Excellent. So we have time for one last question. Anyone out there that wants to come off mute and ask? There's actually one other question in the chat, but I do want to give the opportunity for y'all to chat.
For the shy people.
I know. All right, so the last question kind of relates to the governments, but is a more specific answer, a more specific example of some government agencies are exploring how to adapt this AI and ML to improve efficiencies in their own. So we have CBP securing the homeland, and we have FDA kind of looking at seafood, right? And I think maybe just on the last point, Sandra, how should we be thinking about as importers, how this is going to impact us? What should we be doing to prepare for some of these things?
Okay, yes. I think importers really can't do anything more than what they're doing, and that is making sure they're aware of their own supply chain, the products that they're importing. And the reason why you have to stay on that message, stay on that process, because if the government is using artificial intelligence to target you, they may not have anything to back it up. So you need to have the backup for when your particular ship, because as I mentioned earlier, just like the importers are not going to be able to use the artificial intelligence to determine tariff classification when CB disagrees with it, they're going to have to go and defend it on its own. The government has to defend or make the case against the importers specifically once they identify that something is considered to be a violation. They may use artificial intelligence to target you, make a determination that you are high risk, but actually, in terms of making a claim for a violation, it has to still be specific. So if they're using it more, that means who knows whether their database that the government's using is valid, whether their algorithms, are on target. But the main thing is the importer in defending itself would have to be on its own aware of its supply chain, aware of the products, not just sourcing, but what they're bringing in, and be able to document that whenever something comes up from the government based on their use.
And I love and just want to shout out to Dawn. You attached exactly what we should be doing. We're reading articles and we're understanding where the government is going with regard to some of these things. So if you have seafood in your supply chain, you might be paying some additional attention to that. So I think we tend to do that also with NGO reports in the world of forced labor. Where are they going? Because it is indicative of the government could be using a myriad of different capabilities to target. But to your point, it's still on us to have the facts and data that support, sometimes proving the negative, but it's up to us to kind of make sure that we have that support. So in short, AI is not a replacement to a compliance program. It is a supplement to a compliance program, and it still requires us to do our due diligence and reasonable care support as we move about the cabin. But I also think that that gives us some hope as importers and exporters and kind of adopting this. So I want to thank everyone for attending today's webinar at AAEI. I want to encourage you to register for AAEI's annual conference in June. Sandra, I'd love to see you there. We'll chat about that offline. Details are on our website at aaei.org. Together, we make global trade happen. Keep going, everyone, and have a great day. Sandra, thanks to you and your firm for sharing their knowledge.
Well, thank you all for having me. And I've always admired the AAEI. You were the conference that Customs went to before the Trade Symposium came into existence.
Thank you very much, everyone.
Take care. Bye-bye.
Bye-bye. Thank you, everybody.